Welcome to the review of Lighting Designer Typical Contract Terms with Pamela Danner. My name is Elizabeth Rangard, and I'm the Director of Marketing and Communications for the IALD. Before I introduce our speaker, I'd like to go over some general housekeeping notes. If you have any questions for the speaker during the presentation, please click on the Q&A icon at the bottom of your screen to type your questions. We'll take questions at the end of the presentation. If you have any technical issues, please put them in the chat function and an IALD staff member will respond to you privately in chat. Finally, this session will be recorded and available after the conference. Your microphones will be muted and cameras turned off for the duration of the session. Pamela Danner is a principal of her law firm, Danner & Associates, in Virginia, USA, which is celebrating its 28th anniversary this year. Congratulations, Pamela. Her practice is concentrated in full-service business and nonprofit association representation and estate planning. Pamela has served as the IALD legal counsel for over 30 years. She also provides legal services to several lighting design firms, which includes assisting them with their review and negotiations of their lighting design contracts. Let's welcome Pamela now.
I am very, very pleased to be here today. I know we have people from all over the world, and I have enjoyed working with ILD and over many years, as well as several lighting design firms. I thought that this would be a topic that would be of interest to many of you, a little different than the other sessions that you have been participating in. I want to thank Christopher Knowlton of 18 Degrees Below Limited, a London, UK firm. He has assisted me in providing me with some typical contracts, at least that they have used. I also want to thank David Gatton, who has also provided me with some contracts. I actually assisted David's firm many years ago with setting up their model agreement. They have tweaked that over the years. And I looked at a model services agreement that he provided me from the International Federation of Consulting Engineers, similar to the AIA or the American Institute of Architects model contract. So before I actually begin further, I would like you all to take a few polling questions. So Joe is here to help me as well as Elizabeth. So Joe, if you would handle the polling questions.
Sure. Okay. So you'll see on your screen just where are you from? We just want to know where everyone's from so Pamela can get a better idea of the audience she's talking to. Pamela, do you want me to share the results with the audience too?
Yes, please
okay.
Share the results with me.
Okay. I'll once we get to a higher percentage, I'll let everyone know. All right. Some people are answering in chat. There is a poll question that should be up on your screen. Thank you for sharing there. All right, I'm going to stop the poll. We're at 82%. So I'm going to end polling now and share the results here. Do you see those on your screen, Pamela?
I certainly do, and I find it very interesting. Elizabeth told me that we have 50 countries represented at this Enlighten Europe, and it looks like 18% from Northern Europe, the rest of Europe, 42%, and even 18% from Asia and North America, 14%, and a little 2% from South America, and 6% from others. So that's wonderful. So if we could go to the next question.
Sure. Okay. So this is, you can choose multiple answers for this. If you fall under business owners and lighting designers, you can choose both.
And if you would share this as well, Joe.
Of course. You guys are quick with your polling questions. Great job. We're already up to 85% complete. So thank you so much for doing this. All right.
This is very helpful to me as well.
All right. I'm going to end that. Thank you for answering those so quickly. Share those results with everyone.
93% lighting designer, that doesn't surprise me. Business owners, 34%, which I'm sure many of you are both, and other, 14%. So that's a nice mix. Thank you. And I think we have 2 more.
Let's go to that right now. And launch point. This is an easy one. All right, thank you for sharing. Keep it going. I see the numbers of participations climbing, so thank you for participating in these polls. It'll help Pamela out a lot. All right, once we get to that percentage, I'm going to stop. Okay, let's stop it right there and share.
Okay, that's interesting. percent said yes, and 71% said no. Very interesting.
All right, and the final one. And launch poll. Launch, sorry about that. There you go. This is also multiple choice. So you can choose as many of these options as you'd like. All right, looks like a couple more people are jumping in. All right, I'm going to stop right there so we can get moving on. Here we go.
Are your contracts usually with? And we have 74% says owners, architects 77, general contractors 43, government 35. So that the top 2 are owners and architects, which does not surprise me, but it's certainly a nice mix. And that really helps me lead into the beginning of my presentation. So who is your client? And that's very important to know. And as you can see, it can be an architect, it can be a owner directly, and as well as a general contractor. And that may also mean that you're either a prime contractor or a subcontractor to an architect. For the general contractor may be a prime to the owner, the architect a sub to the general, and the lighting designer a sub to the architect. So it puts you 2 tiers down. And this reflects on how your contracts are handled. Also, the government is a totally different client, and that may be as a prime contractor or again as a subcontractor to an architect probably. So we will go on to the next. So what I'm going to be doing is going over the various typical contract terms, and that is scope of services, client's responsibility, payment of fees, insurance, indemnification, intellectual property, confidentiality and non-disclosure, warranty, termination or suspension of the contract, jurisdiction for disputes, professional credit for the designer and publicity, and just other general provisions or miscellaneous provisions. Most of your contracts will have these different categories. They may be in a different form. They may not use exactly the same language, but it will still be using the same principles. But we can talk about that later in the question and answer session. Scope of services. That is a very critical provision. You should try to use your model agreement with your proposal. However, many times your client will push back and want you to use his, her, its agreement. So then you can use your model agreement to compare to their agreement. But the scope of work is what you present. You present that in your proposal. And that is critical. You need to be very precise. I have looked at David Catan's model agreement, and he may or may not be on today, but he is extremely precise, and it helps you know when your additional fees will kick in. So, for example, you need to state how many in-person meetings during each phase you are providing for, how many revisions you will allow, how many site visits in the construction phase are under the scope of services. The client needs to provide reasonable notice of these meetings and visits so that you won't have some other project that you're having meeting and this client wants a meeting at the same time. You should only provide a certain number of reviews of lighting fixture submittals that you have not generated. The provision for key personnel. You will set forth in your contract who on your staff and you will be working on this project. So who has the authority to remove and replace the key personnel? You should have that authority. The client may push back and want approval. You may agree if the approval is not to be unreasonably withheld. However, you should retain the right or the duty to replace by a person of comparable competence. That should be the how you would look at who should be replaced and with whom you can replace. We'll go on. Another key provision is not just your responsibilities, but the client's responsibilities. And that should be in your contract. So, timeliness. The client needs to establish and present a preliminary project schedule at the time the contract is signed. You need to have deadlines by which the client is to respond to you. If the client doesn't meet those deadlines, then the project schedule needs to be revised. It shouldn't be that you have to suddenly catch up. The client and other contractors need to provide required, accurate, and complete information within certain timelines. This needs to include drawings, specifications, services, surveys, and reports pertaining to the project requirements, as well as other documents affecting you as the consultant's work, such as estimates of construction cost, bidding documents, and contract documents, including change orders. The client needs to have its electrical engineer review all lighting documents in a timely manner, which includes conformance to all local codes, and in Europe, many cases, a national code. The client needs to provide you a listing of all parties providing services to the project. And the client needs to provide coordination so the team works together in an efficient manner. This is the client's responsibility. The client must submit within 28 days of your request. This is according to the model agreement of the International Federation of Consulting Engineers, reasonable evidence that financial arrangements have been made and are being maintained, which will enable the client to pay you. Go on to the next slide. This is a critical provision. We all want to be paid for our services. And you typically, as I have seen, have provide a fixed fee proposal by which you get a percentage of your fees at each phase. These fees need to be paid. I have seen model agreements, which I agree with, within at least 30 days or less. The International Federation of Consulting Engineers model contract says shall be paid within 28 days of the consultant's invoice. And it also says if the client withholds payment, the client must give 4 days notice prior to the payment due date of the reasons why. And then there's a process for handling that. Now, in the US, I know at least, the architect may want to pay when paid if you are a subcontractor to the architect, which is a problem. But if so, and you can't negotiate out of this, then at least it needs to state your contract that you be paid within a set number of days for paying after the architect is paid. I would state that this should not be more than 5 or 7 days. Now, we discussed earlier the need to have in your contracts a provision for additional fees, that you are paid these additional fees when something goes outside the scope of services, or that the client, a service the client has requested or requests after the contract is signed, that is not included in your agreement. You need to set forth that services beyond the scope would be paid as additional fees, and you need to set forth your hourly fee charges for each person on the project as additional fees. You can also charge for reimbursable expenses. The client should reimburse you for travel, meals, reproduction, shipping, messenger services, etc. This should be provided in your contract as well. Okay, we'll go to the next slide. Almost all contracts have a provision for you to have certain insurance coverages. The contract should provide for the kinds and amounts. These should not be unreasonable. And in fact, the client should accept the coverage that you already have or pay for additional coverages if the client wants you to have them. However, and some of the typical insurance coverages, at least here in the US, are commercial general liability, an umbrella liability that's over and above your commercial general liability. In the US, workman's compensation by statute is required. It may not be required in Europe. And professional liability. And this is if, for example, the client comes back and says that your services do not meet the standards of a professional lighting designer and something's wrong, something happened. This would cover you as a lighting designer and your staff. Now, none of these amounts, so whether it's a $2 million per occurrence and $4 million aggregate, should not be excessive. It should be related to the size of the project. And I have seen that sometimes the amounts are highly excessive given the particular amount that you are working, your size of your part of the project. Certificates of insurance. Usually these are required to be provided. But I would suggest language that says will provide if requested. Sometimes it requires that you provide them prior to commencing work on the project. Another issue is how long must you maintain this insurance coverage? The best would be not longer once the project is completed. That should be the length of time. However, many require so many years after the project is completed, and those should be as limited as possible. Now, with Christopher's contracts, I did see that it said 12 years after practical completion certificate is issued. This, in my opinion, is too long. However, he said that it could be even longer because sometimes there is a delay in issuing the practical completion certificate, which would be a problem. This should be the client's responsibility to get this completion certificate issued. Okay. Indemnification. Now, this may go by another name, but it's still a provision in almost every contract. The problem is the client often wants it to be unilateral, that you indemnify the client in a very broad way, and you are not indemnified. It should be mutual. And my experience is that you can negotiate that you can get the client to agree to make it mutual. It also should not be overly broad. You should not be responsible for the work of the client's other contractors. You should not be responsible for the omissions of the client or the client's consultants. So be very careful in how this is worded, and by all means, make it mutual. Intellectual property. This is your intellectual property we're talking about your drawings and other documents. The best is for you to retain ownership of your drawings and other documents. However, many times the client will insist that you hand over the ownership of these documents. One pushback would be to give a non-exclusive license instead of handing over ownership. They should not be using your documents on other projects. So I know this is often a matter of negotiation. Confidentiality and non-disclosure. Now, this is usually a part of your contract, and many times it comes forward that you are supposed to keep confidentiality and non-disclosure of the owners or your client's documents and information, but it's not stated that it should be mutual, and it should be mutual, and usually this can be negotiated to be mutual. Upon termination, what happens? Each party should hand over or destroy the other's documents upon request. But it is my opinion that confidentiality should survive after termination. Many contracts have a number of years stated for survival. I would suggest making that as many as possible or indefinite. Warranty. Now, this may be stated in other ways, but it's usually included in some manner in every contract. It should not be overly broad. Watch out how it is worded. For example, this would be an okay wording. The consultant shall endeavor to perform services in character, sequence, and timing to conform to the project schedule as provided to and accepted by the consultant, you, at the time of the signing of this agreement. Or the model from the International Federation of Consulting Engineers the consultant shall have no other responsibility than to exercise reasonable skill, care, and diligence in the performance of his obligations under this agreement. That is your standard. That is a legal standard that basically you are to perform your services as another professional lighting designer would in like circumstances and at a professional level of reasonable care and diligence. Now, Christopher told me that sometimes in the UK, there are collateral warranties. And what happens if you are the subcontractor to a contractor that defaults? You should not be responsible for other contractors' work, only yours. However, the client may still, if there is a collateral warranty, have a legal connection to you through this collateral warranty provision. So be aware of this. All contracts have provisions for termination or suspension. However, the reasons for these, whether it's for convenience, without cause, or for cause, should be spelled out. Notification. You should be in writing with at least 30 days. At least 30 days either way, and it should be mutual. You should be able to terminate or suspend as well as the client. So for example, without cause, either party should be able to terminate or suspend with not less than 30 days written notice. If the project is abandoned for more than 90 days, the consultant may terminate by written notice. This is a provision that would be recommended and I have seen in model agreements. The consultant may terminate for cause or suspend if the client does not pay you as required by the contract. I mean, you should be able to terminate or suspend if you're not paid within a reasonable time. The contract may say 30 days, 28 days, however it is provided. I have also heard that there are disappointment fees, and these would be a penalty for the client terminating a project early. This is because many times you have a fixed fee contract. So if you have a fixed fee contract, there should be a penalty for pulling out early because you have dedicated resources to this contract and not been able to use those resources for other clients. Jurisdiction for disputes. This is can be very critical, particularly for you all that do projects worldwide. You are located in one country and you do projects in other countries. So where is the jurisdiction? Usually this is where the work is being performed, but that can be a big problem. For example, you are in the UK and are doing a project in Dubai. What law applies? This can also be a problem if in another country where you are not located. To provide for this, there should be a process that is outside the court system of that particular country. I recommend a dispute resolution process that includes first mediation and the process for mediation and how to have appoint a mediator. Then if that does not resolve the issue, then there should be a process for arbitration. And that should also discuss how to appoint an arbitrator or more than one arbitrator and who pays for the arbitration. I recommend that should be the end. It does not go to the court system. Some contracts then say, then you would go to the court system. There should be a provision for professional credit for you as the lighting designer and for you to have allow for publicity of the project because this is your work. The contract should provide that you will be given professional credit whenever the project is publicized. You should be allowed to publicize the project as well. You can state in the contract that the client's consent is required, but the contract should state that consent cannot be unreasonably withheld. It's important that you be given the right to use photographs of the project because this is how you publicize your work. You should be allowed to use the photographs for your own publicity. You may have to allow the client to consent to their use. But again, this consent should not be unreasonably withheld, and that should be stated in the contract. We are finally at the probably the last provisions of your contract, and those are other general provisions or miscellaneous provisions. And one of those may be assignment of your contract. Again, this should be mutual. Many times the client just says that they should be allowed without consent to assign the contract. It should only be allowed if written consent is given, and it should not just be required of you, but also of the client if it wants to assign the contract. Because who knows who then you would be working for, and you should have the ability to agree or not to such assignment. Subcontracting. If you believe that you need to hire consultants or subcontractors as part of your work on this particular project, then you need to provide for them in your contract. If something comes up and they have not been provided for, you may need to get the client's consent to bringing them on. I have been very pleased to provide this summary of what I think are typical contract terms for lighting designers. I've noted that many of you have not used an attorney in reviewing your contracts. I recommend that you do. At least you can have an attorney work with you on a model agreement. That way you have a basis for which to review your client's proposed contract if they will not accept the model agreement. We are no longer in an age of a handshake. I know maybe many of you have you've received contracts from your client, whether it be the owner or the architect or the general contractor. But you do have more power than you may think. I know business is difficult and they often have more resources than you, but it is still, you still have an opportunity for pushback on terms that are unreasonable. So if you have, I've provided my contact information here. After this session, if you still have questions, feel free to reach out to me. I have enjoyed working with the IALD staff for many years, and I appreciate Elizabeth and Candace and Joe's assistance today. And I think that we are now ready for questions and answers.
Hi, Pamela. Thank you. That was a lot of wonderful information. In fact, we're getting a lot of questions in here. So the good news is everybody, we have time for question and answers. So please use the question and answer icon at the bottom to submit your questions, and we'll get to as many as we can. So the first question I have from the audience is, how do I handle disputes if the project is in Dubai and the owner architect wants the jurisdiction to be in the UAE?
And I briefly covered that. I think you really need to set forth a process outside the court system. And it should first include just basic mediation. And that can be very simple. You can provide for how a mediator is selected, that can be mutually agreed to, and go through that process first. And most things can be settled that way. Normally, the parties do not want to drag out a dispute. If it can't be settled that way, then in your agreement, you should have an arbitration process. And there are arbitrators internationally that can be selected. It can be one arbitrator that you agree to with your client, or it could be 3 arbitrators, 2 of which, one that you select, one that they select, and then a neutral one. And there should be timelines for which this arbitration occurs. You can even, in this day and age, it does not have to be in person. And it usually is a fairly quick process as opposed to the courts. And I would recommend that it be a binding arbitration, and that would, the result of that would be honored, and that would ultimately resolve your dispute.
Great. Thank you, Pamela. We've got a couple more questions here. One is from an audience member asking about intellectual property. What is the difference between ownership of documents and of the design embodied in them?
Well, in essence, they are one and the same. They overlap because the document shows the design. And you don't want the, you could say that you basically, the design itself is what you're not transferring ownership of. But if they have the document, they can continue to use it. And you only want them to use it on your project that you're being paid for. You don't want them to continue to use it without being paid.
Great. Thank you for that. Here's another question. What do you suggest in the case if the contract details are not yet signed and the project is requesting to start the design process?
That is not a good idea. They need to sign the agreement before it starts. I have seen where that, and lighting designers will go forward without having an agreement signed, and we'll still be working on the agreement, but you're at risk if that occurs.
Good advice. Another question we have is, with competition over projects being greater than the total amount of projects many design firms are like, let me rephrase that.
Yes.
Sometimes punctuation does not come through. With competition over projects being greater than the total amount of projects, many design firms are likely to skip a lot of these contractual demands to not come off as problematic. What do you think about that?
I know there's a lot of pressure to get work, and ultimately things do come down to a business judgment of risk. However, the risk is there still, and it does not necessarily take that long to come up with an agreement. You may have to give in on some terms, but you still need an agreement. And I think that the pressures are there. You may have to agree to some things you don't want to agree, but you still need a basic agreement. And I think some pushback on things that are totally unilateral is worth it.
Good advice. It's not being a problem to have a contract. Have a basic contract. All right, we have a lot of notes in here about how this information is so useful. How much of this content should be included in the work proposal before getting to an agreement or a contract draft?
Okay, I think as I put forward, when you put forward your proposal in response to the request for proposals from the client, I would suggest that you provide your model agreement with that proposal. So you can be proactive. You go forward with your model agreement, and then the client can come back with signing your model agreement and your proposal, or providing theirs. But I think that you should have yours ready and submitted with your proposal.
All right, we have more questions coming in. We'll try and get to all of these. Here's another question: how to launch these terms to our clients if they have never done this before and they feel like it's too much to handle? How do we handle this?
Well, I suggest having a simplified version. You can have, I realize some clients are really not very sophisticated, and maybe the project is relatively small. So you can actually have a simpler version that kind of gets the basics with your proposal. Maybe it's even a letter of agreement with basic terms. And then for the more sophisticated clients, you have a more robust agreement.
And we had another question. You answered 2 in 1 there. Here's another one. We've been asked to increase our PI insurance coverage by 5 times, and the client has agreed to pay for the additional premium. The problem is that the deductible increased tremendously. How can we offset that exposure?
That's interesting. It's good that the client has agreed to pay for it. And how to offset the exposure, maybe through an umbrella policy, which is like, okay, if this particular insurance cannot really handle it, then we have an overarching policy. But that probably I would have to look at in more detail.
Okay, here's another one. What is your take and recommendation to prevent theft of intellectual property regarding shared digital files that are used while the design teams are working together? It's a long question.
Yeah.
Is a non-disclosure agreement enough? What if they have your files and the client says they got accidentally hacked and therefore your designs leaked?
Well, first of all, you should have a non-disclosure agreement with all the entities or all the team members that will have access to your documents. Whether it's enough for a hacking, you may need some cybersecurity insurance. I recently just took that out for myself. And most professional liability policies now allow you to have that option as well.
All right. How do I negotiate the amount of insurance coverage that I must maintain?
Well, usually you can go to your insurance company and get some idea as to what the basic insurance coverage you need. And then you can look at the particular size of most of your projects and get an idea from that. Often the client will come back with what they want. What I've experienced though, they tend to want coverage that they may require of, say, their general contractor, which has a lot more exposure than you do. So I think that when you look at kind of what your insurance company or agent is saying and the size of the project versus what they may want you to have, thinking that all they're going to do is ask for the same amounts as the general contractor, the architect, that is unreasonable. So it really depends on the particular project, but I think you just get your basic coverages for what you would normally be doing.
All right. Here's a question regarding professional credit. What if they don't do it despite the clause in the contract?
Well, That may be when you need your attorney to write a letter, because the contract is there. You need to push back, remind the client that that's in the contract, and you expect them to honor that. It's a matter of how much you're willing to push back. But I think that you definitely, if it's in the contract, that is a provision that they need to adhere to.
Pamela, here's a question, and I'm not sure how easy this is to answer, but it's about the contract length. If a contract includes everything, about how long should it be?
I don't even know. I've seen contracts of so many different lengths, and it also depends on, I saw that, for example, the UK contracts had different components. Sometimes they were almost repetitive, right? But it was a format that's used there. It really kind of depends on where you are working. They don't have to be that long. Let me see here. I can give you an example. This one is 13 pages and includes pretty much everything that needs to be there. So that isn't unreasonable, but as I told you, if it's really a very small, simple project, you may want to, I mean, it could be shorter.
I think that's helpful. I think the person was looking for general guidelines, so that's helpful. Here's another question for you. In the standard terms and conditions page that needs to be enclosed at the end of the contract, do you have any good examples? Are there some references? A lot of people are asking for examples.
Well, that doesn't have to be that long, but typically it'll have the provisions that I talked about, the assignment and some other provisions, but it usually includes what law applies. It includes that this is the entire agreement and any change has to be in writing. It includes that, anything else here? Sometimes the indemnification is in that part, but maybe 6 or 7 clauses covering some of those basic, what law applies, what the jurisdiction is. This is the entire agreement. Assignment has to be mutual with written consent. And any prior negotiations are superseded by this agreement. Those are just some of the general terms.
All right, this is a broader question. You work with lighting designers on their contracts. What are the most common mistakes that you see that are made in contracts?
I think a common mistake is just signing whatever you're given because of the pressure to get the work, which, you know, I can understand. This is not the best business climate, but that still is not necessary. Others are to basically not have like the client's responsibilities included. Another part is scope of services. You're really too general. You're not specific enough to really nail down what is beyond the scope of services. And that really comes from your proposal.
Well, that's good to know. So we have another question here. It is very specific. And for all of you out there, please feel free to put your questions in the QA at the bottom. Pamela has purposely left time to answer many of your questions, so please take advantage of it. This question is about the model agreement that you mentioned. The person is asking if it is the FIDIC 2017 White Book model agreement.
Okay, good point, good point. It's the FIDIC And this actually happens to be 4th edition 2006. So you may have a more updated version, but I would imagine it's fine too. What year did you say, Elizabeth?
We had 2017.
So that's a more updated version, which is probably even better. I mean, this is a very, I found, very fair agreement. It's mutual in many respects. It also has very definite time periods for when you get paid and how disputes are handled. And I'd be interested in knowing how many of you all are actually using this.
So there's another question here. Is a notice to proceed by email valid in court? And I imagine these days, maybe with more digital, email might be perceived a little bit differently than it did before, but is it considered valid?
I mean, it depends on the particular court and jurisdiction because they all have their own rules. And unfortunately, some have not been updated. I know here in the States, we have that problem that some are still archaic. But in general, it would be acceptable. As long as it's in writing, you can print it out and show it's a written notice to proceed.
Pamela, I'm going back to the opening of your session when we had those polls open, and you were surprised to see how many people did not use an attorney. What?
70%, something like that.
71%, yeah, 70%. I think this has to do with a lot of lighting designers might be individual practitioners, or they might have a very, very small office, and they're doing lots of different things. They're probably doing more than they want to. And legal might not be there. They might not think it's important. What advice would you give them?
Well, I have to tell you that some of my lighting designer clients, several of them are lighting designers that set up their own business. They may be single practitioners, and they saw it as something that they needed to do as part of establishing a business. And I think they have felt, I know we attorneys are not necessarily cheap, but they have felt that it was valuable. So I think that wherever you are, as when you set up a practice, no matter whether you're a single practitioner or partners or a small staff, it is one of the basic procedures and operations that you should look at in at least coming up with a model agreement or a simplified and a more robust agreement. And I'm aware that you have limited resources, but you can usually work with an attorney and come up with kind of a reasonable amount that would be charged for some very helpful advice.
That's helpful advice, since 71% of the people are not using attorneys, and it sounds like there's a lot of risk in that. We have a few more questions here, and we still have time. When exactly do you think we need to put contracts and model agreements on the table? If we're still trying to land a project, when do we start bringing this up?
Well, as I said before, I think usually you're responding to a request for proposals that they're putting out there. Sometimes maybe not, maybe they're just coming to you. They haven't asked anybody else for bids. But usually I would incorporate it as part of your response. And if not, they're going to come back on you and send you their agreement when they accept your proposal. So then but either way, it should occur before you begin working on the project.
Thank you. Here's another question. Is there any way to include a policy that establishes any warranty of payment due to the suspension of projects by the pandemic or by any other catastrophe? Now with COVID-19, I'm sure we're all facing many new things, and this is one of them.
Well, you should have a general provisions about suspension, and that you need to be paid up through work completed during the suspension, and that after so many days of suspension that you are allowed to terminate the project, whether that be 90 days. For COVID, this is difficult. We're now into 10 months. Or that when the project comes back up, that you could, are allowed to change some of the terms. Obviously, the project schedule, maybe somehow some of your fees. So there should be some basic provisions given suspension regardless. And ultimately whether you want to terminate it and be paid for all work completed up to that point.
All right. Well, speaking of COVID and the pandemic, we are living in a different world now. We're living in a very digital world. It was mentioned that people have taken out cybersecurity insurance. What changes have you seen in the last few years that people need to be aware of, given digital, given the pandemic, things that they may have not considered before that now we're all facing?
Well, for example, when I was talking about site visits or in-person meetings, obviously that is not happening now. And given the fact that many of you live in one country and do projects in others, you've probably done virtual meetings anyway, but I know you all used to travel a lot. I'm sure that's not occurring near as much as it used to. I think that you're looking at how to transfer documents securely, how to virtually meet. Certainly, I have to do that too with my clients. So you need to really make sure that your computer software has many ways to be secure and to prevent, have various programs for updating and preventing hackers from coming in and getting your documentation. My husband is a software systems has business, so I'm very fortunate because he's constantly providing me with various updates to prevent to provide safety against all these risks. But it is, I would suggest maybe you're going to have to look at some professional software systems help, because this is probably not something that you are used to doing as much. I'm sure you're very able to, do work on computers and handle getting your documents, but the risks now with all that's going on in the world in terms of software and transmission are fairly great.
Well, Pamela, thank you so much. We have actually run out of time. I do think we answered many of the questions that were submitted, and your session sparked so many questions. It's wonderful. I know you gave your information available for people who want it, but thank you so much. We really appreciate it, and wonderful information.
Well, thank you, Elizabeth, and thank you, IALD team. I am very impressed with how you have handled virtual conferences, this Enlighten Europe as well as Enlighten Americas. I think it's extraordinary. So I applaud you. And thank you all for attending. I'm very pleased to have been able to be here today with you.
Thank you.